Good morning, everybody. This is Erik Daly from Miller Johnson speaking. I'm joined today by my corporate colleagues, Loic Dimithe and Chelsea Austin. We are all in the corporate department at Miller Johnson, and today we will be discussing some of the most recent updates and developments related to the Main Street lending program. Before we jump into the substance of the program, I always like to begin webinars, and I think as a whole, our firm takes the approach of beginning the webinars by reminding ourselves of the spirit and ethic of collaboration and candor that we try to bring to these presentations and engagement with community members and clients as we're all trying to navigate this pandemic and hopefully the recovery from it as best as possible. So we try to bring our kind of core values of ingenuity, intellect, cooperation, and resourcefulness to these presentations and to other ways we engage with the community throughout this recovery. The other thing that we often do at the beginning of our morning coronavirus updates is just to touch on some news developments, and we have a lot to discuss today on the Main Street lending program. So I'm not going to get into a lot of detail on some of the coronavirus related news developments, other than to say, at a 10,000-foot level, seems like statistics-wise, new cases, confirmed deaths in most states, including Michigan now, the trends are favorable toward more of a flattening of the curve, if you will, and that has supported, particularly here in Michigan, more reopening of the economy and businesses. And specifically here in Michigan, some rollbacks of aspects of executive orders, restrictions on hospital visits and things like that. Not completely, of course, but incrementally. So that will continue to play out. We in Michigan were not among the first states to do that. So other states, are several weeks or longer into their reopening, and well, obviously everybody's keeping an eye on what trends emerge, both from a public health perspective, but also economically in those states. And then separately, one related topic that I did want to specifically note, just because it also relates to lending under the CARES Act, is that the U.S. Senate approved the Paycheck Protection Program Flexibility Act unanimously yesterday. That bill had been sponsored in the House and passed the House overwhelmingly. So now it will presumably be signed into law by the president, given the large level of support for it, and that will be the subject of its own future client alert and/or update. Although we did discuss those developments late last week on Friday on a webinar after the House had already passed that bill, and the bill that the Senate passed was unchanged from the House version. So if you watched our webinar on the PPP last Friday, nothing's really changed compared to what we discussed on that slide. So having said that, why don't we move ahead with today's presentation, because as I said, we have a lot to cover. Our topic is the Main Street lending program, and I'll just do a couple slides of background here to provide some context for the updates of late last week. So the CARES Act, which was signed into law in late March, authorized and encouraged really the Treasury and the Federal Reserve to establish some kind of Main Street lending program. The contours of that program were first announced in early April, and basically what was announced is really kind of a partnership between the Federal Reserve and the Treasury Department, where the Treasury Department is funding what they call seed money of $75 billion, I believe, of its appropriations under the CARES Act to support an additional amount of lending by the Federal Reserve. And actually, we now know that the Main Street lending program will be administered more specifically by the Federal Reserve Bank of Boston. So in the presentation here, we generally refer to the Federal Reserve, but for purposes of the Main Street lending program, that'll mean the Federal Reserve Bank of Boston. And the idea is for the Fed to be able to purchase up to $600 billion in loan participations that satisfy the requirements for Main Street lending programs. And as one common theme that I think we'll see throughout the presentation is that because this is a Federal Reserve funded program, without getting into a lot of granularity on this, the Federal Reserve isn't really authorized to engage in risky lending. So a common thread here will be that this program is really not for borrowers that are on the verge of bankruptcy or that were in a bad financial situation coming into the pre-pandemic period. So it's going to be a relatively kind of narrower set of borrowers that are going to qualify for this program than may qualify, for example, under the Paycheck Protection Program. So the initial announcement included two separate facilities, one for new loans, or the Main Street New Loan Facility, and another for expanding existing facilities, or the MSELF. And there were term sheets that were announced at that time for both of those facilities. Why don't we move ahead to the next slide, because after the initial announcement, the Federal Reserve and Treasury received feedback from lenders and then just the marketplace in general. They requested comment from the public and from potential program participants. And based on that, as well as their own internal processes, they put out revised term sheets for the original two loan facilities, the new loan facility and the existing loan facility. And they announced the third facility, the Main Street Priority Loan Facility, which has a lot in common with the new loan facility, except that it's generally geared toward borrowers that might be more leveraged based on their EBITDA. So it allows for higher EBITDA multiple-based lending. It also allows for refinancing existing debt, but the lender in that case has to retain more economic risk. So in general, for the new loan facility and the existing loan facility or expanded loan facility, the borrower, the lender is retaining just 5% of the loan risk, while the Federal Reserve is taking on the 95% participation. In the case of the priority loan facility, the lender is retaining 15% of the loan risk, and the Federal Reserve is taking on an 85% participation. So those are somewhat riskier relative to the other two facilities for the originating bank. Next slide, please. So for more details, and there are a lot more details about the terms of each of those three programs. Again, we've done two previous webinars on the Main Street Lending Program. The most recent one, which is probably from late April or early May, when the new term sheets were announced, summarized those terms. The term sheets for the programs were not changed through these latest developments of last week. really what we had was just a number of new forms released, certifications, agreements, basically additional details and materials for both lenders and borrowers to use and reference as they gear up for the kind of go live of the Main Street Lending Program in the coming days. And in addition to that, the Fed updated its FAQs, or frequently asked questions, for borrowers and lenders. So there's more guidance on several of the issues that people had questions about, like eligibility criteria, so like affiliation issues, program terms and conditions, and some of the plumbing or administration of the Main Street Lending Program itself. So that's what we're really going to cover today, is those additional kind of incremental developments. Again, our prior webinar, which I'll link to in the chat section when I hand things over to Loic in a bit, covers the specific terms of each of the 3 programs in more detail. But why don't we keep going? I suspect a lot of people in the call are familiar with those general terms already. So in terms of the new guidance on some of the, from some of the frequently asked questions and areas where we got some additional clarity from the Fed, one was this requirement that an eligible borrower has to certify that is unable to secure adequate credit accommodations from other banking institutions in order to participate in any of the Main Street lending programs. And for those who have been following the Paycheck Protection Program, this is sort of a corollary issue of, I guess, a need certification type concept for securing a PPP loan. Here, the Fed has provided a little more guidance, I guess, about what this means compared to the Small Business Administration and Treasury in the context of the PPP, although it's still not crystal clear to me. But the guidance, such as it is, says that in order to make the certification, the borrower basically has to state that the amount, price, or terms of credit available through some alternative banking arrangement are inadequate for its needs during the current unusual and exigent circumstances. So that doesn't mean, for example, that they have to show that there's no credit available, or some kind of bright line test that would say, no, if you have access to any other capital, then you're not, any other debt capital, you're not eligible. It just means that you have to certify that what is available, if anything, is in an amount or on terms that are not adequate for your situation, given everything that's happening in the economy and with respect to the pandemic right now. However, the FAQ unusually states that borrowers do not need to demonstrate that applications for credit have been denied by other lenders, and they do not need to otherwise document that the amount, price, or terms of credit available elsewhere are inadequate. So they need to certify this as a borrower, but you don't need to demonstrate that there were applications actually denied or otherwise document what terms you considered. That was a bit of a surprise. I think as a matter of best practice, it would still be good for borrowers to retain whatever documentation or correspondence they have with other lending institutions about non-Main Street lending programs that they might have to help create a record that those arrangements were inadequate, but apparently you don't have to, based on the Fed's guidance. Next slide, please. And then another area that we got some more substantive guidance on related to affiliation issues, and there were a couple surprises here as well. One of which was that an eligible borrower in the program and all of its affiliates need to participate in the same Main Street lending program facility as one another. So to take an example, if you had a business owner who had two separate businesses that person, that he or she controlled, they would be considered affiliates of one another. They might be totally different businesses with different financial metrics, different employees, completely separate, but and different debt financing needs. But based on the updated FAQs, both because those two companies have common ownership, they would be affiliates of one another, and they would be required to participate in the same Main Street lending program facility. So you could not have one participating in the new loan facility and the other one in the MSELF, for example. So they're going to have to, the owner controller there is going to have to choose one. And then the other requirement here, which we knew about before but was repeated in the FAQs, is that an eligible borrower can't participate in both the Main Street lending program and the primary market corporate credit facility, which is really for larger borrowers anyway. I think most small and medium-sized businesses wouldn't be participating in that program. Next slide, please. In addition to needing to use the same facility, affiliates are subject to essentially an aggregate cap on their loan amounts. So using the example from before, if you had two affiliated businesses because of common ownership, for example, that each was eligible on its own, each had EBITDA that supported borrowing, let's say, up to $20 million under the new loan facility. They were going to both participate under the new loan facility. They wouldn't be eligible for $40 million in aggregate borrowings. There would be an overall cap applied based on the cap that is relevant for a single borrower under the new loan facility. So owners of businesses that are affiliated with one another will have to decide a couple things. One, which of the facilities is the best choice for all of their affiliates holistically. And then related to that, which of the facilities provides the most aggregate borrowing capacity. That's typically going to be the MSELF program, assuming that the borrowers have existing lending facilities that they can expand upon, because the max borrowing amount is largest under that facility. But it does require that there be an existing loan facility in place to build off of, essentially. So that will complicate matters for those borrowers or those would-be participants in the Main Street lending program that have a number of affiliated entities. Next slide, please. And then kind of applying that to the private equity and portfolio company context, much like the Paycheck Protection Program approach, the Main Street lending program FAQs now state explicitly that private equity firms themselves are not eligible to participate in the Main Street lending program. However, their portfolio companies, if they're otherwise eligible, remain potential borrowers under the Main Street lending program despite being affiliated with private equity, as long as they're otherwise qualified and eligible. So the fund itself could not take out a Main Street lending program loan, but a company in which it has a controlling interest, if it's otherwise eligible, could. But for private equity firms that have multiple portfolio companies, you're going to have those issues that we just talked about with affiliations and all the portfolio companies needing to participate really in the same Main Street lending program facility and being subject to the aggregate cap, which, you know, applies across the board, private equity or not, for affiliated entities. Next slide, please. Another issue that is kind of a scoping issue for the size of the Main Street lending program loan that is available to a borrower is related to EBITDA measurements. The maximum borrowing capacity under all three facilities references a multiple of EBITDA with the new loan facility, I believe it's 4 times multiple of EBITDA, and then under the others, it's a 6 times multiple of EBITDA. The last update of term sheets from the end of April clarified that lenders and borrowers could use customary adjusted EBITDA measurements and methodologies to scope loan size based on the EBITDA multiples. The FAQs clarified that if an eligible lender has used multiple EBITDA adjustment methodologies for a particular borrower or for similarly situated borrowers, that the lender should use the most conservative method that they have previously used. So again, that kind of ties back to the fact that the Federal Reserve is not engaged in sort of risky or speculative lending. They want to, overall here, the program takes a generally conservative approach for leverage and other terms. And that we'll come back to at the end of the program when we're sort of looking at things at a high level and issues related to the Main Street lending program. But this now explicitly says that the methodology needs to be the most conservative method, and that lenders cannot cherry pick adjustments used at different points going back in time. So if a lender's, you know, experience with a particular borrower has been that, you know, they've, in some periods they've made adjustments, in other periods they haven't, they need to try to be consistent in using the same methodology throughout, and they should document their rationale for whatever adjustment methodology they ultimately select and apply to the loan origination. Next slide, please. And then we won't spend long on this slide, but the FAQs also clarified that if there's a material breach or knowing misrepresentation from some of the certifications that are sort of threshold issues for participating in the Main Street lending program, for example, a certification about having significant operations in the United States, that's a requirement for participating, then there would be a mandatory prepayment of the loan. You'd have to pay the loan back. And there are also potential penalties if it's a knowing or a willful misrepresentation, but just something to be aware of as potential borrowers or lenders are reviewing certifications. And so now we'll head to the next slide, and I'm going to transition it over to Loic to continue going through the updated FAQs. Loic, are you you're ready to take over the slides here?
Yeah, thank you, Erik, and good morning, everyone, and thank you for joining us here. So, consistent with the previous term sheets that came out, the loans that are issued under the new existing loan program and the priority loan program must be either senior to or pari passu with any existing loans or other debt instruments of the eligible borrower. And so we've gotten some clarification and some further guidance on that point. In particular, we've gotten a very clear definition of what they mean by loan or debt instruments. It's pretty broadly defined here to mean any debt for borrowed money and all obligations evidenced by bonds, debentures, notes, loan agreements, or other similar instruments, and all guarantees of the foregoing. And mortgage debt has been defined to include debt secured by real property at the time the loans are originated. Next slide, please. So consistent with the conservative theme of these programs, the intent behind this here is to ensure that the loans issued under this program are not at a disadvantage or in a riskier position than any other existing indebtedness. And so as part of FAQ provided some clarification that loans issued under the priority loan program, if they are secured, there are certain minimum collateral coverage ratios that are designed to ensure that the loans issued under this program are adequately secured. Furthermore, to the extent that the loan issued under the priority loan program is secured by the same collateral that the borrower's other debt, again, these loans, the security, excuse me, must be either senior to or pari passu with, in line with, or on the same position with any liens existing and in place for other creditors. To the extent that the existing loan program is secured by collateral, again, same concept here, that the security interest for supporting this loan must be, again, either senior to or pari passu with any existing debt. Next slide, please. So to the extent that the underlying existing debt is not secured or is unsecured, that does not prohibit the existence or the issuance of a priority loan or an existing loan under this program. But again, to ensure that these loans are not disadvantaged or subject to a greater degree of risk than any existing debt, these loans cannot be contractually subordinated in any way to any of the borrower's other unsecured creditors. Next slide, please. Now, with regards to restrictions on repayment of other debt, you may recall that these loan programs prohibit the repayment of any existing debt or the cancellation or reduction of any existing lines of credit. However, the priority loan program allows for, in connection with the origination of the loan, the refinancing of existing debt. And the FAQs provide further guidance on certain exceptions that borrowers may use in order to pay down or pay off any existing debt. Those exceptions being the repayment of a line of credit, including credit cards, consistent with the normal course of business of the borrower, taking on and paying additional debt obligations, again, in the normal course of business and outstanding terms. So you're thinking about inventory or equipment financing. And then refinancing maturing debt is also permitted. Next slide, please. The biggest exception, which already existed in the prior iterations of this program, was payments on debt that is either mandatory and due. We've gotten some further clarification on what exactly that means, and so it's essentially payments that, as of April 24, 2020, that are already scheduled to be paid on certain dates in the future. And in addition, it also permits payments that are automatically triggered, mandatory prepayments upon the issuance of the existing program. So you're thinking about using the priority loan program to refinance existing debt, so it would permit the repayment of any debt that's being refinanced under that program. We're also provided further guidance that to the extent any payment is mandatory and due as a result of the incurrence of any existing loans that is not being fully refinanced, that payment will be permitted to the extent that it is de minimis, or again, to the extent it's used to refinance that existing facility, that existing debt in connection with the priority loan program and the origination of that program. So to the extent it's not refinanced at the origination, it cannot be refinanced later on in the future. Next slide, please. So another big issue that we received a fair amount of clarification on here is with regards to eligible borrowers and what it means to have significant operations in the United States. And so essentially, when making that analysis, we've been advised to consider the operations of the borrower and its subsidiaries on a consolidated basis, but we do not have to consider the operations of the borrower's parents and any sister affiliates. And so that's the scope of that analysis. Next slide, please. And in determining whether one has significant operations, we've been provided really 4 points here that are not exclusive. So to the extent that there are other relevant points, those may be applicable as well. But we have been provided guidance to the extent that the borrower, when consolidated with its subsidiaries, has greater than 50% of its assets located in the United States, 50% of its annual net income generated in the United States, 50% of its annual net operating revenues generated in the United States, and then finally 50% of its annual consolidated operating expenses, excluding expenses associated with debt services generated in the United States. And again, I do want to reiterate, this is not an exclusive list, and to the extent that there's anything that is any other considerations that are relevant to establishing the significant operations, those may also be considered. Next slide, please. With regards to foreign subsidiaries or domestic entities that are have foreign parents, those are eligible for participating in the program to the extent that they are those entities and those borrowers are created or organized in the United States and have significant operations, and the majority of their employees here in the United States. However, there is a point of clarification here that the proceeds of the loans may not be used to benefit or otherwise support the operations of the foreign parent or any foreign affiliates. So, you know, what exactly that means, it's a little bit unclear to what extent what it means to benefit a foreign parent or foreign operations, particularly for operations and company groups that have very close operations and are pretty highly integrated. But it's something to keep in mind as one contemplates applying for these loans and how one plans on using the proceeds of these loans. Next slide, please. So the FAQs provided certain appendices. In particular, Appendix B contains model covenants that eligible lenders and borrowers should reference when drafting and negotiating the loan documents. Among them, you can take a look for yourself, but just generally at a high level, among them include covenants relating to priority and security, mandatory prepayments in the event of a breach, and cross-acceleration and financial reporting requirements. Next slide, please. With regards to financial reporting in particular, the Appendix C provides quite an extensive list of pieces of information that are required to be disclosed both on an annual and quarterly basis in connection with these loan programs. Among them include disclosures relating to total assets and liabilities, total revenue and EBITDA, dividends and distributions of the borrower, total expenses, fixed charges and capex of the borrower, and collateral value reporting will also be required, both to some extent or another on an annual or quarterly basis. Next slide, please. So consistent with the previous term sheets, there are certain fees that both the eligible lender and the eligible borrower are required to pay in connection with these loan programs, and the lender may pass on those fees to the borrower. But we have also gotten some clarification that the lender may charge additional de minimis fees associated with just servicing and processing the loans. And examples of that include legal fees and things of that nature that are pretty customary in connection with loan facilities. So it's just an additional layer of fees that borrowers should be conscious and aware of. Next slide, please. And then another piece of information that we were provided is just some criminal and civil liability potential here for knowing material representations that the lender borrower maybe refers to law enforcement authorities, or may be subject to further investigation, which may result again in certain criminal and civil fees, penalties, and fines. Next slide, please. So with that, that's just an overview of certain high-level clarifications and pieces of information that we got from the FAQs, and now we're going to dive into some of the documentation that was provided, and I will now turn the mic over to my colleague Chelsea also to provide some insight on that. Thank you.
Thanks, Loic, and good morning, everyone. So just diving right in, regarding the general loan agreement, while eligible lenders are permitted to use their own loan agreements as long as they are substantially similar to the documents these lenders use in the ordinary course of their similarly situated borrowers. The loan documents are required to reflect the terms outlined in the loan document checklist. So that can be found at Appendix A of the updated FAQs, and they include concepts such as maturity, principal and interest deferrals, interest rates, amortization, and securities, and things of that nature. Next slide, please. Okay, so regarding the lender MSLP registration documents, so these documents must be signed by the eligible lender's CEO and CFO, and so, or a similarly situated officer, and this must be done at the time of the registration for the specific Main Street special purpose vehicle. Additionally, eligible lenders must submit a lender wire instruction for bank accounts into which the Main Street SPV will transfer the purchase amount, servicing fees, and other payments. So those are two documents that must be sent from the lender during registration. Next slide, please. So these are a list of documents that are required at the time a loan participation is sold to the Main Street SPV. These include the loan participation agreement, the servicing agreement, assignment in blank, the co-lender agreement, the facility transaction specific certifications and covenants, and the facility borrower certifications and covenants. And we can dive more into detail with those, starting with the next slide. So the loan participation agreement, this agreement comes in two parts. The transaction specific terms, this is a document that must be signed and completed in order to effect the sale of the loan. And the standard terms and conditions, this document sets out the terms and conditions for all Main Street loan participations, and it is incorporated in the above transaction specific terms. Next slide, please. So the assignment in blank, both the eligible lender and the eligible borrower must sign this document, and the eligible lender should reference the specific instructions on the assignment in blank's cover pages in order to actually complete this form accurately. Something of note for existing multi-lender facilities under the MSELF program, the assignment in blank form comes from the documentation from that existing multi-lender facility. Next slide, please. The co-lender agreement, this agreement also comes in two parts. So it comes, the transaction specific terms, both, again, the eligible lender and the eligible borrower must sign this document. And additionally, the standard terms and conditions, again, this document sets out the terms and conditions of the agreement, and it's incorporated in the transaction specific terms. Something of note, this document is not required for existing multi-lender facilities. Next slide, please. So the facility transaction-specific lender certifications and covenants. So an authorized officer of the eligible lender must submit one of 3 documents in relation to each loan participated to the Main Street SPV. So whether you are a part of the MSNLF, MSELF, or MSPLF, you need to complete the corresponding certifications and covenants. And while the documents vary by MSLP facility, like I just explained those 3, there are some common provisions in each. And next slide, please. So for the facility borrower certification and covenants, the CEO and CFO, or again, officers performing similar functions of the eligible borrower, must sign one of these documents for each loan participated in the Main Street SPV. Much like the facility transaction specific lender certifications and covenants, there are 3 vehicles, so the MSNLF, MSELF, and MSPLF. And again, while these documents vary by facility, there are common provisions in each. So a borrower would need to complete the form that corresponds to their specific vehicle. Next slide, please. And so that kind of wraps up the documentations that are required. And I will turn over to Erik Daly again, just to wrap up the presentation and provide any conclusions. Thank you.
Thank you very much, Chelsea and Loic. I appreciate that. And I also would say if either of you want to add anything to these concluding remarks, please jump in. The things that we wanted to note for certain, though, are that the Main Street lending program is not a DIY or do-it-yourself type program. And again, to draw a parallel with the Paycheck Protection Program, that application process early on, the kind of front end of that process lent itself to a little bit more DIY type work for borrowers, although many also consulted their accountants and legal advisors. I think that on the front end here, that's going to be even more important, just given the amount of program terms, documentation, and eligibility criteria we talked about. All of those additional criteria, required certifications, affiliation issues, may further limit the appeal of the Main Street lending program to some would-be borrowers. I think also the fact that it's been a little over 2 months since the CARES Act was passed, especially for those borrowers who didn't qualify for the Paycheck Protection Program. They may have already found or identified other funding resources or options that are not the Main Street lending program. So there's a lot of media reporting on this just general topic about how many participants in the MSLP there will actually be. We'll see in the coming days, I think, as it gets launched. But I think there's some skepticism now just because of kind of the fundamental principle again here that the Federal Reserve's not even statutorily authorized to engage in risky lending, even if they wanted to. So there may be some future loosening of the terms if this program doesn't launch well, but it's not going to be, unless there's some change that allows the Fed to engage in riskier lending, it's not going to be dramatic, I would expect. The documentation here is obviously more complex than the PPP loan application and sort of promissory note. There's a lot to do with the PPP to make sure you get the loan forgiveness, but in terms of the actual loan documentation itself, there's not a ton of paperwork, whereas with the Main Street lending programs, there will be more paperwork and potentially negotiation with lenders on the front end of the process than in the PPP context. So whether it's your accountants, your internal finance staff, or attorneys or outside counsel, whoever, it's going to be important to have your professional advisors involved from the outset to understand and to help navigate the terms and conditions for the NSLP facilities and really choosing, which one is the best fit, especially if you have, if you own multiple businesses or, if you're a private equity fund, if you've got multiple portfolio companies, there will be some tricky decisions on the front end of the process. So that's what we had today. Loic, Chelsea, anything? I don't see any questions lined up in the Q&A box, but is there anything else you'd like to say by way of conclusion?
No, other than thank you for joining us, and obviously feel free to reach out if anyone has any questions.
Yeah, and I feel the same for both. Feel free to reach out, and thank you for joining us this morning.
Yeah, thank you, everybody. We really do appreciate the participation in our webinars, and encourage you to contact any of us should you have follow-up questions about this topic or anything else that we've covered in our COVID webinars. So thank you, and have a good day.